Hello, my name is Dana Ingram. I'm the Executive Director with JC Vision and Associates. We are a Fair Housing Initiative program, and today we're talking about tenant landlord issues and the law, and looking at it through the Fair Housing Act lens. The last session we talked about was living inside of an apartment or housing, and what is the necessity on how to work with your landlord to resolve any types of issues. Now we're talking about the move out. What happens when it's time to either move out or it's time for eviction? My first question is, what would cause me to be evicted?
Not paying your rent?
So in the last session we talked about, it is Georgia law that says you must pay your rent no matter what. You cannot withhold your rent. Am I correct on that?
That's correct.
Ma'am.
Okay, so you heard it here. Pay your rent. After that, then all the other stuff falls in place. Okay. What should I know as a tenant as I prepare to do a move-out inspection? What do I need to know, Mark?
9 times out of 10, you have to give your landlord a 30-day written notice. Most places, they'll make you come in and they actually have a form that you fill out that is a 30-day written notice.
Let me ask this question. A 30-day notice because I choose not to renew my lease, or a 30-day notice because I'm getting ready to break the lease? Which one?
That would be either one. There are exceptions in most leases that say if you're going to break your lease, you have to give a 30-day written notice. Now, there are clauses in leases nowadays for military members where you don't get any type of charge or anything for breaking your lease, but there are situations where you have to break your lease due to medical issues. That would be a reasonable accommodation request. Or if you're breaking your lease because you're tired of the neighborhood, you're trying to move. One of those type scenarios, you would more than likely have to pay a fee to break the lease, but all leases require 30-day written notice.
Okay, very good. So what about my landlord tells me that they don't want me to live there anymore? Different than my lease is up, but they just decide you would need to move out, and they told me you need to move out in 30 days. Is that correct?
No, ma'am. Georgia tenant landlord law, they have to give you 60 days written notice.
So that's 60 days at any time that they say they don't want me to live there anymore. So I renewed my lease 3 months ago, and now here we are, and the landlord says you need to move out in 30 days.
In a situation like that where you have a lease binding you to the apartment, but your landlord comes back and says you need to move out, they are required to give you 60 days written notice.
Okay. All right. Well, let's say it's at the end of my lease. I didn't want to renew. I gave my 30-day notice. We're now getting prepared to go ahead and do a move-out inspection. What do I need to know?
What you need to know is the most important thing is the date of your move-in or your move-out inspection. That is where you start your planning. You need to make sure everything is out of your apartment at least a week prior to your inspection so that you have time to clean. Now, some places, they will offer, hey, we have these cleaning companies that we work with. They could come in, they know what we expect. You could pay them to come in to clean for you, or you can do it yourself. Now, if you want, you can go ahead and pay. If not, there are things, they give you a checklist of everything that's got to be clean. So you can go through and clean everything yourself. You want to leave yourself at least a week if you're going to clean by yourself. If you're paying for a cleaning crew, 9 times out of 10, the cleaning crew will come in prior to your move-out inspection, so they'll need a day or two. Or there are some companies that if you use one of the cleaning crews that they recommend, they'll do your move-out inspection, won't charge you for the house being dirty because you have the receipt showing you paid a cleaning crew that's going to come in after your move-out inspection.
Okay, so once again, we're talking about documentation.
Well, not only just with that, if I can piggyback off of it, is because now one thing I try to tell clients to kind of give them a quick general understanding of it is this: when you were moving into that place, it was clean, it was free of furniture, any obstructions, anything like that. What we call that is move-in ready. So if anything else, your number one goal, if you don't have a checklist of things of that nature, is to do your best to make it move-in ready for the next person. With that saying is that you want to basically be able to have this place clean, have all your stuff out of the way. So if a person were to walk in today, after you clean everything, they can start moving this stuff in right then and there, without even have to wait for a cleaning crew, have to wait for repairs to be made and things like that. You've already had that taken care of to your further responsibilities. So therefore, again, it is very important. Mr. Mark, you brought up in the move-in inspection session that you can use the Snapchat filter that has a date and time to authenticate something. It's still best to use that filter again when you're moving out to show that you got these things clean, especially if you're doing it yourself. It's nothing wrong with that. You can go rent a vacuum that has the shampoo and everything with it. Nothing wrong with that, but still document what you cleaned and how you cleaned it, so therefore they can't come back and try to say you didn't do it properly.
Well, let me ask this question. So the landlord says, look, you need to move out. And the reason why that landlord said that I have to move out is because I contacted code enforcement.
That would be retaliation. Under Section 818 of the Fair Housing Act, that is not, that's illegal. They cannot do that.
Correct.
Now, if they do try to do that, then your number one answer should be, you're going to have to take me to court.
And so when we go to court, what do I need to bring? Because I only wanted some things fixed. And I just thought that, my plumbing is running out underneath my house. The air conditioner is not working anymore. My refrigerator is not working anymore. So I went ahead and every time I hit a switch over here, it starts to spark. And my oven doesn't work. I only got one eye on a 4-eye oven. And every time I open the oven door, then it's just smoking.
Right.
And so I asked the landlord to fix it. And then he wouldn't fix it. And then he or she, and then I went ahead and went to code enforcement and reported it. Code enforcement came out and said, well, this is a bad situation here, wrote up a report and everything, and now the landlord's notifying me that I need to move out.
The number one thing you need to understand is a lot of people get confused between an actual eviction being filed against you or a pay and quit letter from a landlord. So an actual eviction gets served by a sheriff's deputy. Once they serve you, you have 7 days to file your response. Within that 7-day window, you have to go to the courthouse, go to the clerk's office, and always put disagrees and then put I do not agree. And then get your day in court that you are authorized. Then the items you need to bring with you is a copy of your lease, a copy of all work orders you submitted to your landlord showing that you requested those items be fixed, a copy of the code enforcement report, and then the letter that the landlord gave you saying you needed to move out. All of these should have dates on them. And in direct correlation with you contacting code enforcement and them doing that report, it will show if the very next action the landlord took was to send you a letter saying you needed to move out in 30 days, that falls under Section 818 of the Fair Housing Act for retaliation.
Okay. So then all of a sudden now I go ahead and the court went ahead and dismissed and said, hey, this looks like this is what you did, Mr. Landlord, Mrs. Landlord. Then what do I do after that? Because now I'm moving back into a place I'm afraid that it might be hostile.
A lot of times it will be a hostile environment. What you do is you still document everything. Never make phone calls to your landlord at that point. Always do everything in writing, because if they're willing to put it in writing, then that right there shows that they're not thinking clearly, number one, and number two, they're not worried about any type of action going against them. But if you're in a situation like that, you need to contact your nearest Fair Housing Initiative program, and you need to get some assistance, because at that point, even prior to the minute you get the letter saying you needed to move out, because you called code enforcement, you needed to contact your nearest FIP, because that right there is a fair housing complaint all day.
Okay. Well, let's say, again, let's go back to the scenario. My landlord says I need to move out because I'm not following house rules. Maybe I had somebody stay over too long, because I was only allowed 14 days in my written lease contract. Now, is that a fair housing complaint?
No, ma'am. If it's for house rules, that wouldn't be a fair housing complaint. But a lot of units that are subsidized, whether it be like the housing authority or a low-income housing tax credit, in their documentation that they filed with HUD, they stated that if they give you anything like that, they have to give you an informal hearing. So in a situation like that, you would contact the office and you would let them know, I want my informal hearing. And then you would sit down and have them show you all the evidence. The regulation states prior to the informal hearing, they are required to give you all the documents they're using for this house rule violation. They're required to give you all their evidence and everything prior to that meeting. If they don't give you all of that, then at the informal hearing, the first thing you need to do is ask where your copy is. Because if they want to say, James had somebody staying for 19 days when the lease said 14, show me documented proof. Show me documented proof that they're receiving mail at the residence. Show me documented proof that they live there. If they do not have documented proof, then they cannot hold that against you. You have to have evidence and proof.
Especially even if they say they have surveillance, you have a right to ask them to look at their surveillance as well. If they cannot produce that surveillance that they allegedly have told you they've seen you on, that's something they cannot hold against you. So I agree with you wholeheartedly.
Now, you talked about an appeal process. How many days do I have to appeal?
Usually about 10.
They say 10 days from the date of the receipt of the letter.
Okay.
So it should say in the last paragraph of the letter, if you want to do an appeal, you have 10 days from receipt of the letter. And that's when you would get in touch with the office. You would walk in, so you're on camera, or do an actual letter and deliver it to the office stating you would like to have your informal hearing.
Now, during that informal hearing, do I still pay my rent?
Yes.
Yes.
Pay your rent. We already said that 3 times. Pay your rent. Okay. Very good. Is there anything else that you think is important for tenants should know about being a tenant and their responsibilities on their tenant landlord?
Yes.
Go ahead.
One thing that you just reminded me of when you brought in that last subject, this just goes for any and everywhere. Anytime you sign your name on a document, you deserve a right to have a copy of that same document. So especially a lease. If you, as a tenant, sit down with a property manager or owner and you actually go through and read all the provisions of the lease and everything, and you agree upon the terms and conditions of the lease, both parties do. Both parties sign their name on it. You do not leave that location, that office, until you get a copy yourself. Not if they're saying their printer's down and everything like that. No, if anything else, if their printer's down, you schedule a date and time to come back and get a copy of your lease. Do not go and live at a location where you cannot readily, at 2 o'clock in the morning, want to go and read paragraph 17 of your lease. You earn the right to do so as a tenant at that location. So at any given time, anywhere you reside, you sign your name for a lease, you deserve a copy. So please, please, please obtain a copy of your lease and read it. It may not be enough time frame or whatever the dynamic may be for you to go through every single line by line before you sign right then and there, even though you should make that time to do so. But if anything else, you still should go back and reread that lease section by section, and therefore that's why it's so important for you to have your own copy.
That, and if they're saying that their printer is down, say, okay, you can scan it and email it to me right now. That way you at least have a digital copy prior to leaving the office, and then still schedule that date and time for you to come pick up the in-paper copy.
Correct. And I'm sorry, but I've also too, when you're signing a lease, even if you're about to renew a lease, pay attention to dates. Do not allow someone to tell you sign something without actually putting a date next to it also. Make sure, or if anything else, if they tell you not to put a date down, put a date down anyway. The date that you're signing right then and there. You don't want it to where, which is why it's still so important that you have a copy yourself of the lease, but it's important that there's a date next to your signature, because you don't want anyone to just go off, try to take your signature off of something and then put it on something else to make it seem like you agreed to this, and you end up with a date next to it. Because do you understand how hard it is to go back and say, that's not my handwriting? Well, how can you prove that? You're creating more things for you to have to prove that you didn't agree to this, rather than you just saying, hey, I put this date down, and someone else put a different date down. You automatically can argue that. The credibility of that is already is weak. So if anything else, that's why it's important to get a copy of your lease, but also put anything you sign your name on, you put a date next to. Don't let anyone tell you they'll put the date themselves. No, okay. I need to witness you put that date down.
All right, so what I want to do now is turn to fair housing.
Okay.
I would like to go ahead and talk about our intake process. When you contact JC Vision and Associates and you believe you have a fair housing complaint, you will go through an intake process, and you will talk to our intake specialist, who will begin to ask you questions about your situation. At that time, she or he may go ahead and send you out an intake packet. That intake packet must be filled out. It's going to ask you very important information about your name, where you live, who the landlord is, what issues are there, and then from there, that intake packet will be received by our office. Once it's received by our office, then we will go ahead and read through what's your narrative, what happened. It's really important, if you can remember, to put in dates when things do happen, because under the Fair Housing Act, you have 1 year, not 1 hour, 1 year from the time of the incident to report what has happened as the Fair Housing Discrimination Act. 1 year. So we will go ahead and look at that to make sure there's jurisdiction under that claim that you believe your rights have been violated. Once we go ahead and look at that intake packet, we will also then schedule for you to go ahead and have an interview. With that interview, that is when we go ahead and discuss everything that's happened. We will go ahead and talk about dates. We'll talk about who was there, any witnesses that you may have, or any other information that you may be able to bring with you, and we talk about that you have. It is really important to collect evidence. We talked about evidence for all the sessions. It is really important for you to document, and again, document. When you come to that interview, bring in all your documentation so that we may go ahead and discuss it then. We'll make copies of all that documentation as we're going through the interview process. And during that time in the interview process, we will look at it to see, like I said earlier, does it have jurisdiction under the Fair Housing Act? And then also look at, is this actually a fair housing complaint? Mm-hmm. Sometimes it will be just a tenant landlord dispute, okay? But if there's elements that show violation of the Fair Housing Act, then we will then go ahead and write up a HUD 903 narrative to go ahead and get that to HUD. Once we write it up, we'll have you review it to make sure that all the dates and information that's in that HUD 903 is correct. Once that is done, then you will sign that document. Once that document is signed, we as your Fair Housing Initiative program here, we will go ahead and send that directly to HUD. HUD will then go ahead and in their intake process begin looking at your complaint, and then the process begins. Once it goes from intake and nothing has to be changed in your complaint, then it'll go to investigation. And that's when a lot more investigation on the situation will happen. Once the investigation goes through its process, then they will go ahead, they meaning HUD, the investigator, will deem if there was actually a Fair Housing Discrimination Act that was made. If they deem that there was one, then you as the complainant have the opportunity to say, yes, I want to go ahead and use the HUD judge or, help me out, the HUD to go ahead.
Oh, take it to federal court?
Federal court, thank you.
Yes.
HUD to take it to federal court, or I will go ahead and get my own private attorney. Did I leave anything out of the process?
The only other thing that you left out is because of the other fact that it can go one or two ways, because an investigator can, while they're actually doing an investigation, they will always continue to remind you that you can always open up the doors for conciliation. And a conciliation is not a payoff, but it is an amount that you can give to the respondent for them to pay you in order for the investigation to end, because that amount would be the amount that you feel would make you feel whole from the violation that they have now acted against you under the certain protected class. So it is not a time to try to think that this is a way to get become a millionaire. No, by any means it's not it. But if anything else, it does give an opportunity for you to give an amount that you feel would make this investigation end. So that's what a conciliation amount is. We do work with you with that as well. We always tell all our clients, this is not a way for you to become rich, but at the same time, put down feasible amounts in which you have documented proof and how you were harmed, and then we will submit that to the conciliator and see if they can negotiate an amount from the respondent to pay you in order for this investigation to stop.
Very good. Now, do any of you have any last words that you would like to share?
The only thing I would like to say is, if you live in the state of Georgia, pay your rent. The biggest issue we have when we go and we assist people when it comes to evictions and everything, the biggest issue we run into is individuals not paying their rent. Pay your rent.
Well, very good. Well, I want to thank you for this opportunity, and I hope the information that we provided is very helpful in helping you to go ahead and abide by the Georgia tenant landlord laws. Thank you again. And if you have any questions, please give JC Vision and Associates, your local Fair Housing Initiative program, a call. Our number is 912-877-4243. You can also go to our website, jcvision.com, and you can go ahead and ask questions there. We're on Facebook, we're on Instagram, and I believe we're on Twitter too. So at any time, give our office a call. We are here to help you. If you have any questions, let us know. Please do not be embarrassed about it. We are here to help. Thank you so much. Have a great day.